This presentation will last about 30 minutes, and a recording of the webinar will be available on the Wagner Law Group website shortly. And you can access previous webinars on the website as well. Let me introduce our speaker, David Gabor, a partner with the Wagner Law Group in the Boston office. Welcome, David.
Thank you, Barbara. Hello, and thank you all for joining in today. American Apparel is a domestic apparel company that has worked hard to create and promote its brand. It takes great pride in the fact that it did not outsource its manufacturing. Many recent posts in the media don't mention this or any of the company's successes. Unfortunately, the company has experienced a host of problems that led to legal issues and resulting negative media coverage. People can differ in their belief as to what brought about its troubles. This is especially true when much of what happened was avoidable. I have no interest in discussing my feelings about Dove Charney, its board of directors, or its executives. I sincerely doubt that you have the time or interest in water cooler gossip. Suffice to say, allegations have been made about sexual harassment, retaliation, abusive employment agreements, abusive confidentiality agreements, ineffective investigations, ineffective support from executives, and American Apparel's board, which has all led to its current troubles. The truth is of little comfort. What was published in the press is what people hear, and this hurt the company. American Apparel and its executives and its share owners have suffered, no doubt about that. However, American Apparel is not alone. Many other companies have been harmed by litigation and bad press. As I've mentioned in prior webinars, no company wants to share a headline with the Equal Employment Opportunity Commission. No good comes of that. Despite all of the coaching and counseling out there, far too many companies are facing unwanted litigation and claims. In 2013, 93,727 charges were filed with the Equal Employment Opportunity Commission. That does not include cases that went straight to state court, state agencies, directly into arbitration, or were settled before charges were filed. 38,539 charges were filed with the EEOC for retaliation and 27,687 for sex discrimination. $372.1 million was recovered by the EEOC in 2013. It claims that that was a record. All of this does not take into consideration litigation or recoveries in private proceedings. Add that to this $372 million, and the numbers are staggering. Much can be learned from the allegations made in the American Apparel case. Much of what we will discuss can apply to your organization. To that end, please don't hide behind the adage, oh, this won't ever happen to me. What we're going to talk about are things that you may recognize as things that may, in fact, potentially affect your company. If there is a concern that you have after listening to the webinar that does not appear on the list, or we did not spend enough time on it, talk to a trusted advisor, a professional, and write it down, and remember to do it right away. Who conducts investigations? If there is even the slightest potential for a conflict of interest or the appearance of impropriety, the investigation should be conducted by someone outside the organization. A conflict of interest occurs when there is reason to believe that the investigator has personal knowledge of an event or is related, either familially or economically, to a party or a witness to the investigation. Anything that would hamper an impartial and fair investigation. The purpose of the investigation is often overlooked. If there is wrongdoing, then the corrective action should be taken. But what else should be done? When the investigation is completed, the notes and the records are assembled, all you've got to do is toss it into the shredder, right? No, no, please don't. Steps need to be taken to figure out why a complaint was made, why there may have been inappropriate conduct, why it may have gone on for some time, and a fix needs to be put into place. What do your policies say about who is made aware of an investigation? Do you tell the board? Do you tell the executives? Our employees are made aware of it. This needs to be worked out prior to doing investigations. If there has been prior investigations and even the slightest overlap, you may want to check your processes to see why it was allowed to continue, because that's a sign of potential problems down the road. Watch out for retaliation. That is the #1 charge being filed in the federal courts, and it's oftentimes the most difficult to defend. And it's so important to take steps internally to avoid even the slightest hint of retaliation, if at all possible. Was an employee abusive? Why? How so? If you start with the premise that there is no way that David could ever have done that, oh, I know David too well, he wouldn't do anything like that, then you miss the point of the investigation and the anti-harassment processes in the company. Remedy the immediate concern and protect against repeat offenses. Also be careful not to prejudge or predetermine the outcome of any investigation. Prevent future abuses from this person. Each additional offense can come with a lot of baggage. In the court system, it could come with punitive damages, and they can be significant. What the culture is often depends on how one responds to complaints. Many handbooks boast a zero-tolerance policy. Not everybody follows that zero-tolerance policy, and that creates a host of mixed messages we'll talk about later. Unwanted litigation. Defense counsel proudly presents a decision granting the motion to dismiss. Look at this, General Counsel. I got the case tossed. I am wonderful. Hear me roar. While relieved at the outcome, the General Counsel is not terribly pleased by the price tag for the defense fee and the disruption to the workplace. As large as that fee is, it pales in comparison to fees and risks in cases that survive a motion to dismiss. And as we said earlier, it goes without saying that nobody wants any kind of bad press. One of the interesting issues is the use of confidentiality agreements. The immediate reaction is that these agreements will be favored because they limit the ability to discuss uncomfortable topics with third parties. However, they must be viewed in terms of internal and external factors. First, the internal factors. If the goal is to prevent the bad stuff from winding up on the General Counsel's desk or with the Board of Directors, then you've got a real problem. It's clear that people in this company don't want the truth to be shared with other people, and you've got a culture and you've got some processes that need to be questioned. There may be unintended consequences of a confidentiality agreement, even if it's not drafted that way. There are external factors. The EEOC disfavors any confidentiality clause that limits the ability of an employee to go to the EEOC regarding discrimination or to in any way oppose discrimination. The NLRB will attack any confidentiality clause that limits the ability of an employee to concert. And the NLRB recently, as recently as this week, has demonstrated that it is being real tough on companies. Look at the decision from the General Counsel of the NLRB on the McDonald case. Human resources. is still an often underutilized part of many organizations. On too many occasions, HR has told me that HR is the last to know. The decision was made to terminate Julie, but there's no paperwork to reflect the reason that the department manager made that decision. Or Barbara was fired yesterday, and now the manager comes in and says to HR, we fired Barbara. Create the paper trail to justify our decision. This kind of thing happens again and again and again, and this handcuffs counsel when these types of decisions are questioned in court, because counsel does not have any paperwork to support a decision. And that's only one side of the problems when HR is not used properly. And sadly, sometimes HR is viewed as a hall monitor or a traffic cop, and that's it. What is more important is how HR can limit risk and exposure to litigation and terrible press. I am not from the camp that believes that stock HR policies are better than no policies at all. Let's start with the notion that policies are essential for the success of the organization. However, the procedures and resulting responsibilities must be manageable and realistic. Anything less won't do. Take the time to get it right. Mechanisms. If our goal is to encourage reporting, then there must be a reason for people to report and a corresponding abatement of concerns that tend to lead people away from reporting. Examine who receives a complaint, the boss, HR, a hotline. Can the complaint be anonymous? Can confidentiality be promised? What about reprisal? Training. Many companies either fail to put training in the budget or provide inadequate training. The result is that it is a missed opportunity. Great training programs do more than just satisfy legal requirements. They reduce risk, volumes of complaints. They can promote team building and even a sense or a belief that the company cares about its employees. HR can lead to accountability for one's actions. Once again, set the bar high. HR can ensure that conflicts do not play a part in decision making. Whether there is an accusation that there was an improper action or an inaction. And finally, employee engagement. A company going through a world of hurt is likely to also suffer from poor or no employee engagement. The end result, HR can and often does foster and maintain great employee engagement, and consider the benefits that that creates within your organization. Consider the leadership roles that people fill. CEO, CFO, COO, CIO, GC, Director of HR, and the alphabet soup titles inside a company. Who fills the roles? What do you expect of these people? Do they have the tools and the latitude to run the company? Or, to the contrary, are they handcuffed? If so, why? Organizations typically expect their leaders to put the best interest of the company first. Sadly, that is not always the case. Many leaders face a conflict between what is best for them and what is best for the organization. This can be the product of a number of different factors. There could be a question of a duty or loyalty. There could be an economic concern. There could be a fear of reprisal. What if a leader has poor performance? What if you're not sure whether their loyalty is to the organization? Why would you as a company accept anything less? And what happens sometimes is you have an employee with an employment agreement, and they can't get rid of the employee because although the performance is poor, it does not violate the agreement. Or you have a person who is a great employee but the agreement doesn't protect that individual if the individual speaks out about concerns regarding other people in executive positions in the company. Employment agreements are a terrific tool to secure and retain the best talent in a company. They can empower executives to act by using language that states that acting is part of the job and is within the scope of authority. This eliminates the fear that some executives have. They can clearly define authority so there is no confusion over what the executive can and cannot do. We don't run into a situation where there's a renegade executive or an executive who would have done something but didn't realize that it was within the scope of their position. Once again, set the bar high. By setting the bar high in any organization, it eliminates much of what we have seen cause litigation in many other cases. If the executive abuses authority, hold them responsible. Build this into the employment contract. Don't tolerate the problem child. These agreements can eliminate conflicts that may make executives reluctant to act for fear of losing their job. Build in language to protect an executive for reporting if done within an established process. I have come across many instances where executives were paralyzed by fear. A good employment agreement and other things we're talking about today should eliminate that in the majority of situations. And perception is relevant for contractual employees because they may be scared to rock the boat. Similarly, at-will employees also have issues pertaining to perception. An at-will employee can be terminated for any reason or no reason at all unless it violates a statute or a common law. These employees are often the people who know or reasonably should have known of some form of harassment. One challenge is to get these people to speak up. Tell Sam to stop. Will he do it? Report this to my boss. Oh, that makes sense. Report it to HR. Sounds like a plan. Do nothing. All too often, this is the case. Put yourself in the shoes of the employee and think about what you would do if you were placed in this dilemma. Who will influence your decision? Will you turn to external influencers, friends, family? What will they ask you? What will you tell them? What is the culture in your organization? What are the things that you're going to think about before either following path A, B, C, or D? It is so important to ask questions. Have a trusted network of professionals that are resources that you can work with that are a phone call, a cup of coffee, or an email away. In fact, that's something that I do. I've got colleagues who are HR people, who are attorneys, who are accountants, and we talk with each other on a regular basis so that when we are working on our files, we're giving state-of-the-art advice to our clients, and we've got each other's back. This is a significant mutual benefit that you can all enjoy if you are not already doing that. And your network is going to help you identify risks that you may not otherwise that you may not otherwise see. Think about the number of rules and regs and statutes and laws you have to follow today. And for those who've been doing this for 20 years, how much more there is to know today than there was 10, 15, or 20 years ago. You can't keep up on that and do your day job. That's why you need to have a team around you. Because if you don't know that a rule or reg exists, then you can't very well know that you're missing the boat on that requirement. So work with people so that you don't miss out on an expectation, either by an employee or by the government, etc. Kick the tires in the company. For example, someone says that this has always been the policy, a pay scale, a reporting structure. Probe, question it, confirm that it is correct. Having an open dialogue with people that you report to and who report to you is important. Just as I stress that you should ask questions, be gratified that those below you are asking questions as well. That's a really good sign if they're doing that. The line about never assume, because when you assume, you make an ass out of you and me is tired. I know that. Sure, grown. You've heard it way too many times. At the same time, the cost associated with unwanted litigation and audits is equally tiring. Are your policies adequate? Are they up to date? Are they compliant with all laws and rules? Have they been disseminated? Are they actually being followed? Is appropriate action taken in response to complaints? Does the team work in concert? Are you assuming that the folks in legal are handling it? Or are you making the assumption that HR's got it? Find out for sure that it is being handled and do not let it fall through the cracks. Employee classification has been a big issue recently. The focus, keep in mind, is on what the person is doing and not what a job description says that they are doing. Please ask questions on this one because audits and litigation can be extraordinarily costly. Requests for accommodations are a focal point of the EEOC. Verify how managers respond to requests to ensure compliance. When a manager is under a lot of pressure to meet a deadline and one or more employees come in and say, hey boss, I need this accommodation. I can only work so many hours, or light duty, or I can't do all the position, but I can do most of it. And the manager says, no, Alex, I want you there 24/7 doing your full job, no exceptions. The reason why the manager is saying that is because the manager is under pressure to get the job done on time. However, that response can expose the company to unwanted litigation. And again, retaliation. I put this in a couple of times because I can't begin to tell you just how important it is. People talk a great deal about the culture at the company. We don't do that sort of thing. On too many occasions, the general counsel and I have a conversation and she says, well, we thought that would never happen here. There is no way that Kelly would ever do that sort of thing. Sadly, what we often regard as a culture is not the same thing that others see. There are 4 important takeaways on this slide. Identify the desired culture and then put together a plan to back into that culture. 2, figure out what are the important characteristics for success in all positions and how people should interact within the company, its customers and vendors, and disseminate those expectations. Watch out for the trap when experiencing rapid growth. Many times when a company grows quickly, people are put into supervisory positions without either a proper selection process or proper training, and those people make mistakes. And 4, set the bar high. You heard me say it before, set the bar high. Let's talk about the board. In a company, I know not all organizations have a board, but for those that do have a board, these are certainly pertinent. An effective board can have a profound and positive influence, assisting the company in its short, mid, and long-term planning, helping to ensure proper financial decisions are being made, looking at the records, looking at the reporting on these financials. oversight over legal in the company? Do you have proper contracts with the attorneys? Are you selecting appropriate attorneys? Are you monitoring the fees charged by the attorneys? Is general counsel on his or her game? Reporting to the board promotes transparency. Have department heads and executives report to the board, have a record of that reporting, and make it transparent. Force executives to account for major decisions and challenge them as needed. Make certain that correct decisions are being made regarding the retention, external and internal. Boards can promote positive structure within a company, and boards can ensure that we've got the best and the brightest talent. An effective board could be amiable. An ineffective board could be amiable, or it could rubber stamp every decision made by the company. A board can be contrary and debate every decision to death. Either extreme is dangerous. Get a good, effective board with the best quality people. Your policies have to work for your organization. No one size fits all works for any company. If you don't follow every bit of a policy, then the policy is wrong. If a process is too cumbersome, change it. If you don't think you're going to have time to follow up on things, change it. Let's talk about, for example, a complaint is made about an employee. Mary accuses David of sexual harassment. And the water cooler gossip runs rampant. And David and Mary get into the saga that everyone, or a lot of people, at least in that department of the company, know about. But David is allowed to continue to work there. First message, he is too important to discipline. He is so big, he's bigger than the rules. That is what employees see. Then they see there's a rule that's not being enforced in David's case. Again, the conclusion, he's larger than life. And perception. The organization really doesn't care about Mary, or doesn't care about sexual harassment, or whatever it is that David is accused of doing. Because the perception is what the employees see, and the employees don't see the whole picture. They only see what they've been told. And keep in mind that all the opinions are based on that knowledge, and that becomes the message being sent to the company. That's what the coworkers know, and that's what the coworkers take into their day-by-day work. So let's talk about things that do work. Let's talk about employee manuals. The employee manual, if it is something that is followed and it's something that's workable, helps the company from the perception of making it clear to people what they can and cannot do. And if it's followed and people know what they can and cannot do on the job, then the risk of deviation from what they can do is reduced. If it's not followed, you have anarchy and you have chaos. If it's written in a way that the employees don't understand, that doesn't help either. Training. If we let the people know those expectations in the policy, we disseminate the policy, and we train on the policy, we're doing what we need to be doing. Importantly, when we train on policies, we're also talking about our culture, we're talking about expectations, we're sending a message that the company cares about its employees, and that's why we train. We make sure that managers and supervisors understand the policy and follow the policy and have an ongoing interaction with their reports on a regular basis. If an employee is surprised by what's in a performance evaluation done on an annual basis, then the manager is not doing the job. Reporting. We talked about that earlier. Our culture is a culture where people report, but the way it's done has to work within that company. And some people use a hotline system for anonymous complaints. Other people say you go to HR. Whatever you do, make sure that reporting is feasible inside your organization. And audit. Every now and then, find out whether or not people are following the policy. Check to make sure there's proper classification. Check to make sure that a complaint is handled the right way. Check to make sure investigations are actually being conducted and there is follow-up on the investigations. If you do this stuff, you eliminate the risk associated with things like what happened to American Apparel. So let's go over the 10 things, or actually 11 things that we talked about. The investigations. There are some great people all over the country that can do investigations in person, by telephone. If there's the slightest risk that someone sitting on a jury is going to believe that your investigation was not fair or impartial, refer it outside. Confidentiality agreements. Although it may seem like it's a great idea to have confidentiality agreements, if it pertains to complaints of anything having to do with the terms and conditions of the workplace, there are internal and external risks. Get the most out of HR. Give your HR every bit of room to be a profit center in your organization. Make sure that you've got the right people in executive positions, and these right people in the executive positions are able to do the best work of the company, and are not, for whatever reason, handcuffed and prevented from doing that. Use employment agreements to help ensure that you have the right executives in positions in the company and that they are empowered to do the work they need to do. Consider the perception of your employees when your employees experience any kind of concerns in the workplace. Are your employees going to publicly state that concern? Are your employees going to ignore them, make believe they haven't seen whatever's going on, or are they going to work with you? Ask questions. Don't assume that things are being done right because that's the way they've always been done. Don't assume that you know everything because the laws are changing on a constant and regular basis. Have a team around you of great professionals who are resources that are available, and that helps an awful lot. Find out realistically what your culture is, not what you think it is, but what it is, and then think about what it should be and take the steps to move the culture in that direction. Have a great board. Think about the precedent of your actions and what that says to the people that you work with, because your actions speak an awful lot louder than your words. And your processes should be processes that work for your company. Avoid those one-size-fits-all issues and have great processes. Thank you very much for joining in the program today. I enjoyed talking with you about this, and I should tell you that back when I was in college, I had a choice between being an attorney or going into education, and one of the reasons why I do these programs is because I really want to help all of you to avoid the problems that stem from poor or less than satisfactory practices. If I can help any of you avoid those kinds of problems, it would be my pleasure. Thank you again.
Thank you, David, and thank you to everyone for attending this webinar. A recording will be available on the Wagner Law Group website shortly, as well as the PowerPoint slides. And if you have questions, please contact David, and he'll be more than happy to answer any of your questions that you have. Thank you very much.